What is it you're asking us to do?
In the first of 3 hearings thus far in the Florida courts, I have no injunction on me, except after that hearing, the judge slapped a temporary injunction on me for 15 days, and I'm about to share with you why. November 29th, 2023 was our first hearing for LIEnette's temporary injunction against me in the Florida courts. Now, previously, George and I had attempted to get injunctions on LIEnette and John CROOK, and we were told that 2 offenses have to happen, criminal charges, and then a third, and then you can get an injunction in Florida. In other words, it's almost near impossible to get an injunction. Now, if you've seen this first hearing that we have shown in its totality, foul language, vulgar language, and all, you see that this judge is leading and guiding this witness, or LIEnette, the petitioner, who is acting as her own witness. The judge is not acting as a judge. Now, I understand for a pro se litigant, there's some leeway in regards to the process and systems in court. That does not permit a judge to act as a lawyer, and that's exactly what this judge did. Acted on her behalf as a lawyer, to the point of nothing was ever heard from me in that first hearing. At the tail end of that hearing, my lawyer and the judge start this little verbal altercation. Can you put yourself in my lawyer's position? We've been there for hours. And not to mention, LIEnette tells the court that she has an abusive ex-husband that's watching a life-threatening child. It's in a vehicle. She's in a vehicle with an abuser. Why has that judge not stopped everything immediately and called DCF? That's what I want to know. Is he a mandatory reporter or not? Everything should have stopped right then and there. But we have witness right there from the witness, the petitioner, abuser, child is in a vehicle for hours upon hours, and that's the only place they ever were. Huge issue if you ask me. And yet there was no cross-examination. There was literally no real evidence produced. It was all hearsay. All those hundreds and hundreds of pages that Lizzie Bailey printed out for LIEnette, a person that LIEnette's never even met before in her life. All this paperwork, all the transcripts, which you cannot trust transcripts from YouTube. Let me make that very, very clear. From YouTube. It gets it wrong all the time. Doesn't matter. It was all hearsay. All of her narration or letters of recommendation of support, all hearsay, all of it. There's actually been no evidence whatsoever. And yet the judge is keying in on one specific thing. The statute has changed. Has there been direct or indirect contact with the petitioner? In other words, what the judge is doing is holding me liable for anything somebody else does in regards to contacting or threatening LIEnette. Holding me liable for something somebody else does. That's a huge issue. And that's the only thing he's focused on here. There is absolutely nothing wrong with any video I've put out whatsoever. There's nothing wrong with any meme or anything in a community post or anything I've said in a live stream. There's literally nothing wrong with me or any of my employees or any individuals that are independent contractors have worked for me, have done or said or posted. Nothing. That's not the issue of this case. The issue of this case is what have others done, and are they going to hold me liable for that? Now, you're probably thinking right now, hold a second, we got a pretty major case going on in our country right now with a person who used to be the president. Yeah, major issue. Number one, it's an aspect of freedom of speech, and I have that freedom of speech, and I exercise my freedom of speech. And if you don't exercise your freedom of speech, you're going to lose your freedom of speech. And this is what's happening in this court. I'm losing my freedom of speech, or at least the judge is attempting. And the judge actually did. And the judge took your freedom of speech away, which I'm going to get to in just a little bit. Yeah, your freedom of speech. And you're going, Jeremy, isn't that socialism? Isn't that communism? Trying to control the media? Yes! Absolutely. The judge not only took away my freedom of speech, took away yours. Yours, if you're watching right now, this judge took away your freedom of speech in my temporary injunction for something I didn't even do. But we're going to get to that. That's what the judge is actually focusing on, the indirect communication, the indirect responses from people, because I showed something on media. Okay, well, we see things on the news all the time. Are we going to start actually jailing news broadcasters? Are we going to start jailing anybody who writes an article in the paper? Are we going to start, is the whole world going to have injunctions because they exercise their freedom of speech? I don't think that's practical by any stretch of the imagination. Now, many of you have surmised that maybe this judge is trying to set a precedent within this new statute and create law. And I don't think you're too far off from that thought process. There is a huge possibility that this judge is trying to create a name for himself in this new statute stating indirect communication and trying to create law attributed to his name. But the issue really is this. Number one, there has been no actual evidence. Okay, we've heard that there's been an email from John Smith. Who's John Smith? Okay, well, nobody knows who John Smith is. LIEnette could be John Smith. You understand that, right? Okay, now you actually have to prove that they actually wrote it because they watched something or read something that I posted. Well, you have to realize that everything I've posted has been just a repost from her or public information from Florida Fish and Game and Wildlife, right? So it's public information. Anybody has access to it. She's provided it publicly, and she is a public figure. Not to mention running for office multiple times. She just put in another letter for the open position in Otter Creek.
Well, I make a motion that we appoint Miss LIEnette Preston. She wrote a letter and asked, and she ran in the last election.
All right, I have a motion. Do I hear a second?
Do nominations have to be seconded? I don't think you have to have a second.
Because you certainly didn't second when Zim was nominated.
All right.
If it's a requirement, fine. but
All in
you just have
favor?
to be consistent.
All in favor of LIEnette Preston?
Aye.
All right. All opposed?
Aye.
Aye.
Public information requests are beautiful things. December 14th, 2023, Commissionary Board. I would like to inform you of my intentions to run for a seat on the board of Otter Creek. Thank you, LIEnette, MLA, and the letters can go on and on and on. Preston. By the way, there's a huge debate right now whether Preston is even her legal name. We've run a full background check on her. It ain't Preston. And yes, I did redact information out of respect, even though this is a very difficult individual to have any respect for whatsoever. At the end of this first hearing, you see the judge say a couple different things. Number one, all right, we're going to rehear this, or we're going to continue the hearing tomorrow morning, which my lawyer states that I have legal obligations up in Ohio. Now, this is pretty important, because in hearing number 2, the judge hammers and hammers and hammers on this issue that I stated, or my counsel stated, I was in trial versus LIEnette and John CROOK. No, nobody said the word trial. My lawyer didn't say the word trial. I never said the word trial. The only person that ever said the word trial was the judge. As a matter of fact, check it out right here.
You guys want to come back on a Saturday or Sunday? I'll be here on a Saturday or Sunday. You want to come back at midnight? We'll be back at midnight. Want to come back tomorrow? Let's come back at 9 o'clock. So, are we reconvening at 9 o'clock?
That's fine. I have a doctor's appointment, but I'll cancel it.
Mr. Hales is having to address matters in Ohio court related to this situation. He has to be there tomorrow morning. He has a flight out.
Well, who's the judge in Ohio? Why don't we reach out and see what they can do to accommodate us?
Judge
in
Ross.
effect, we're not going to have it tomorrow because of Mr. Hale's.
I have other commitments
Calendar.
as well, Your Honor.
It's Judge
Okay,
Ross.
so your calendar and his calendar take priority over the court calendar.
Then the judge, in his inappropriate anger, again, my opinion, but in his inappropriate anger and poor behavior in the courtroom, he sets the next hearing for December 6th. And without any opportunity for the respondent's side, which would be me, LIEnette is a petitioner, I am the respondent and my lawyer, and if you look at the clip, you will see our backs are turned. We are talking about conflicts of scheduling, and then the judge abruptly adjourns the hearing.
We'll be back here Wednesday, December 6th at 1 p.m. We stand adjourned.
I was free that day. Unfortunately, my lawyer was not. He had a medical procedure that he had actually scheduled out months ahead of time, but he had no opportunity in court to actually share that. But he did file a motion for continuance, in which this judge denied. Well, come to find out, none of that mattered anyway, because LIEnette actually implicated him as a witness and got a temporary injunction order on me. And this is how. Days after the initial hearing, George and I were in a meeting with our lawyer. And all of a sudden, out of nowhere, well, we were regrouping. We were strategizing what our plan was for the next date and filing a motion for continuance since he had the medical procedure, things along those lines. And out of nowhere, the assistant says, "Oh my goodness, they just denied the continuance." And then it was, "Oh my goodness, the docket just updated. The judge granted a temporary injunction order," which all of us, all of a sudden, were going, what in the world is going on? This judge has denied multiple times any type of injunction whatsoever for LIEnette against me, on the premise that there was no evidence. And this first hearing, he ended the hearing with the same premise. There has been no evidence to give any support for a temporary or even a final injunction order. So here's what actually happened. LIEnette goes to the court and she files a motion as she's representing herself. And here's what she does. She pathologically, that's the word that she's looking for in court, but she can't seem to find, pathologically lies yet again. She files a motion stating that my lawyer attempted to pay her off to make this go away. All right, number one, I never believed that my lawyer would do such a thing such as that. Number two, there is no evidence whatsoever. Where's the evidence? So you can find this motion. This is all public record. She files a motion and says that my lawyer offered her money to pay her off. And what does the judge do then? The judge immediately files a temporary. I know what you're thinking already. You're going, a judge is filing something based on one person saying something. So it's she said, and then we didn't even hear the he said. It's really LIEnette said, she said, he offered me money to pay me off. And we haven't even heard in court the he said? Yes. He filed the temporary injunction on me, a 15-day temporary injunction. And not only was it on me, it was literally on you. And he filed it based on this bogus, false, pathological lying motion that LIEnette actually submitted for herself. Here, I'm going to read it for you, word for word. Here it is, public information. And if it wasn't, I'm making it public. It's my information. Now, the very first illegal thing that is in this temporary injunction, it keeps me 500 feet away from their property. Now you understand, and I understand, that they stalked me to Otter Creek and they bought property 1.66 acres across from my 70 acres on purpose, trying to get money from me. Now you realize legally a judge cannot keep you from your own deeded property, and he did. Very illegally. And you will hear me address that with him in hearing number 3. Now, the second thing that he does is he takes away your freedom of speech and mine, but the important thing for you to understand, yours. By the way, if you're in Levy County, this judge is up for re-election this year. And by the way, this judge is taking away your freedom of speech. I'd have something to say or do about that if I were you. So let's take a look here. We know we got the 500 foot, but what he does is he puts in this addendum. He writes this himself. This is an addendum to the actual injunction. There we go. Look at it right there. Addendum, LIEnette Preston, Jeremy Hales. You can see the judge. So ordered this 6th day of December. Boom, right there. Okay. Now it says the 6th day of December because that's when I was served. It says, based on the totality of the circumstances presented to the court in prior pleadings and in the form of evidence, hold a second, what evidence? All we've done is seen hearsay so far, and evidence presented at a prior hearing of record held on 11/29/23. Let's stop right there. He had already said at the end of 12/29/23 that there was not any evidence for a temporary injunction. Now here he's saying because of the evidence, all right, let's keep going. And based on the extension of what the injunction relief due to the respondent's request to continue the hearing to 12/6/23, which was previously set both with his and his counsel's knowledge without objection, the judge did this with our backs turned and adjourned without any opportunity to say anything. You saw it in the video. And in consideration of the issues implicated regarding the potential prejudice to the petitioner, if such conditions which follow were not imposed, it is therefore ordered, basically, because the petitioner lied and said that my lawyer offered her a bribe, a payoff, a bargain deal. I think you're all smart enough to know that LIEnette has never gotten a single penny of my money, nor would I ever give her a single penny of money. She is a scam artist, she's a con artist, and that's how she's lived her entire life with John Crook. They are crooks, and they will never get a penny of my money. So to sit there and say such things, such as my lawyer offered her a payoff, is just so absurd. And therefore, it's ordered and adjudicated as follows. In addition to all conditions and restrictions previously imposed as set forth in the extended injunction for protection against stalking, the following restrictions and conditions are imposed. And this is what he typed up. This is what he made. The respondent, which is me, and or anyone under his control, employed by him, and or in any way under his direction, including to, but not limited to, any and all administrators of any form of social media, has the responsibility to assure that he does not publish in any form whatsoever utilizing the media platform conduit information of the name, the image, the likeness, or any information, data, photography, videos related to or pertaining to the petitioner or her minor child. All right, hold a second. You're saying he can't do that. It's freedom of speech. You are correct. He cannot do that. He illegally took away my freedom of speech. Not only did he take away my freedom of speech, he took away anybody's freedom of speech on social media. Now, LIEnette posts things all the time, which I'm sure many people have seen. Her lovers, her haters, her people in the middle. He's literally saying anybody says her name, image, likeness, any information, data, photography, videos related to, I get a charge. I go to jail. Now, hold a second. I know what you're thinking. You say, Jeremy, but you didn't do it. How in the world can he say that you can't do that and then you're going to be held responsible and you're going to be held accountable for what somebody else does? So you're saying LIEnette can go out, create a fake profile, take her own image, take her own video, and post it out there, and I would be in trouble? Yes, based on what he put in here, yes. So some of you are going, oh my goodness, for about 2-3 weeks, every time I typed LIEnette's name, it got deleted. Well, guess what? I would have went to jail because of you. Not because of me, because of this judge saying that you don't have freedom of speech. He took away not only mine, he took away yours. He took away everybody's. It is socialism. It is communism. It is illegal. It is not okay. And yet, he still did it. Not only did he do that, he was so upset that he said and filed a motion that I had to present proof to flying to Ohio for the contempt of court case, which he said in his words, trial. And again, you'll see that in the actual hearing. He is hammering on trial, trial, trial. Nobody said trial. He's the only one that said trial. Complete and total misinterpretation. And so he says I have to produce proof, which, by the way, I did. I produced my plane tickets. I produced the paperwork that I had to be there to sign and notarize to file for contempt of court. I produced my lawyer's name and number, which he said he was going to call. And he declared that I did not produce evidence needed to be in Ohio. Now, I'm kind of curious how in the world you can say, all right, I'm going to call your lawyer. I have all the paperwork that you filed. I have your plane tickets. You absolutely were there. I have a lawyer confirming it. And I did not follow his motion, which says here, respondent is to present proof of travel and appearance in court. Look at this right here. An appearance in court. There is not one person in that trial, in that hearing, the very first hearing, that said anything about an appearance in court. It was said I had to fly to Ohio to deal with these matters. It didn't say a trial. It didn't say appearance in court. And yet this judge puts in writing appearance in court, present proof of travel and appearance in court. And then he makes a ruling that I didn't provide what he actually said I legally had to provide. Nobody in the world said trial but him. And nobody in this world can take away your freedom of speech. Not even him. This put myself and George in quite a predicament because now LIEnette is saying that my lawyer did something that never happened. Now that makes my lawyer a witness and no longer my lawyer. And you're thinking, well, why can't he still be your lawyer? The judge is acting as her lawyer and he's still a judge. Doesn't work that way. And I have days, literally days to find legal representation because my lawyer now is going to be standing trial as a witness against LIEnette versus actually being next to me and representing me as counsel. So I have a temporary injunction order on me. I can't go even on all of my property illegally. I can't say or exercise my freedom of speech illegally. And I have to find another lawyer. And so I do. And we find another lawyer. And our new lawyer says the best offense is a great defense. He knows we have civil protection orders against LIEnette and the Crook from Ohio. And he also knows the state of Florida must enforce them. Of course, the issue that we keep running into is the state of Florida is refusing. The Levy County Sheriff is refusing based off the information they're getting from the state attorney. The state attorney has written them an email that says, I caution you. This verbiage exactly, which by the way, this is going back to Ohio in the courts. The state attorney is saying, I caution you to enforce these civil protection orders. The state attorney has been quoted as saying, Ohio has no jurisdiction in Florida. So now we got a judge, now we got a state attorney, and we got Otter Creek. My lawyers are looking at me literally in a meeting and going, Jeremy, how far do you want to take this? How far does the corruption go? We've gone from Otter Creek to Levy County Courthouse, now to the state attorney. And we've got the Levy County Sheriff in between, refusing to do what they are legally mandated to do. And we're all looking at each other with our jaws dropped going, how far is this going to go? Now, I think you know me well enough. I've told them we're going all the way with it. All the way. We're going to fight every aspect of it. The only thing that I want to have happen is for everybody to do the right thing. Might sound like a broken record. And as I state that, remember, the right thing is always the legal thing. You should never contact anybody on our behalf. Now, if you need to contact Children's Services because you see something that's illegally happening, you have every legal right to do that. If you need to contact a state attorney because you see something illegally, if you need to contact Fish and Wildlife, you have every legal right to do that. You should never be contacting anybody in Otter Creek or anybody that you see in our videos. This is YouTube, the largest news platform that exists in the world today. And the news is of our life. And this is what's happening in our life. Let us always handle it by ourselves, legally, the right way. And you do things the right way and legally as well. Up comes December 6th, second hearing. My original lawyer is not with me because of a medical procedure scheduled months before. My new lawyer is with me. We go into the courtroom. And the very first thing Judge DeThomasis wants is all this proof of my travel and appearance, which nobody said I was on trial, right? Nobody said I was in a court hearing. Nobody said that at all except for him. It's here. It was never said in court. It just goes on and on. But before we go into court, our lawyer has another idea. He says, listen, you need to take your injunctions and you need to take them to the Levy County Courthouse, and you need to file injunctions in Florida based on your Ohio injunctions. Florida must legally give you injunctions on both LIEnette and John CROOK. They have to, because you already have Ohio injunctions. So George and I spend all morning getting all documentations together and injunction petition letters and copies of all the horrific things they've said. Well, a small sampling of all the horrific. I mean, could you imagine the copies we would give them? I mean, thousands and thousands and thousands of screenshots of the things they've done, videos, you name it. So we get our documents all together and we go and file those injunctions right before our hearing on December 6th. And we're told three things. Number one, you'll either get the injunction and you'll know about it. Number two, you won't get the injunction and you'll know about it. Or number three, you won't hear anything. And lo and behold, as we are going into our hearing on December 6th, I see our injunctions because I put specific things on the documents, not a paper clip, binder clip. I knew the binder clips and I knew where I put them, and I put them on certain areas. On the left was Jeremy, on the right was George. And so I see them in the hands. And the judge is late for the start of the hearing. Why? Because the judge is in his room and he's going over our injunctions. And we think he's going to come out and he's going to say something about it. You know what he says? Nothing. Literally nothing. He says nothing about the injunctions, except George is sitting up front with me, nearest to the bailiffs with the firearms. And the judge says, "What are you doing up front?" And my lawyer says, "Well, she's part of the civil protection orders." And he goes, "If you're so scared of her, why are you this close?" I thought that was pretty obvious. The bailiffs are that close. The protection is that close. She had me and my lawyer in between her and LIEnette. And the judge made her go sit in the back. I thought that was a little inappropriate. I thought the questioning was inappropriate. But then again, I have yet to see appropriateness in this courtroom. We know nothing about these injunctions. And the hearing goes on for an hour and 45 minutes. And there's only one thing to deal with. We need an actual continuance because I had to hire new representation. And you're going, "Jeremy, how much money do you have in this so far?" Well, you're not going to believe it, but I'm going to tell you. I have $32,500 so far in legal fees just with LIEnette and John CROOK. And right now your jaw is dropping. That's between Ohio and Florida. Now, who's going to be liable for that? Well, I can tell you already, I'm suing for back legal fees in Ohio, and there will be more fees. So I'm going after the legal fees in Ohio from LIEnette and John CROOK, and I'm going after legal fees here in Florida, which will be hearing number 3. You'll hear about that sooner or later here in Florida. I'm going after legal fees in both states. Right now, that tally in total, $32,500. $32,500 that could have went to Christmas in the Creek. $32,500 that could have went towards a family in need. $32,500 that could have went towards multiple people in need, and kids, and going to camp, and things that we care about, and cancer research, and you name it. $32,500 for a woman that stands up in a court and says, "I'll do anything to make it end," except she won't stop. Remember, she's the one that did this. We ignored it for months and months and months and months. Then we just shared it. It's news. It's newsworthy. George and I find out later the judge actually seals our petitions for injunctions. And therefore, we have no information in regards to our injunctions at all. And we're not okay with that. So we go back up to the courthouse and we ask for them to be unsealed. As a matter of fact, we pay over $250 to get certified copies of them. And the judge does something very unique. In my opinion, and that's all it is, it's my opinion, he's covering his butt. He writes in there, "You are denied, but if you follow this statute in the state of Florida, they will be held accountable." And he seals it from us and doesn't allow us to have the information. So we have injunctions that we filed. They're sealed from us. He covers himself by saying, "Yep, they broke all the civil protection orders. You follow this statute, and if you do what this statute says, then you can move forward." And what do you think George and I do? We get the statute. We get all the paperwork ready with our attorney. And then we go to the Levy County Sheriff. And you would think the Levy County Sheriff would be thrilled to see us and say, "Hey, there's something wrong going on in Levy County. Yeah, we need to take care of it." There's been nothing but complete and total confusion on their part.
What is it you're asking us to do?
We're not going to show all of our cards. We're going to hold them back. By the time you're seeing this, I can tell you that we had an in-depth all-afternoon meeting with the Levy County 2 detectives in regards to LIEnette and John CROOK.